As we spend more and more of our lives online, protecting our personal data from misuse has perhaps become more important than ever before. From Aadhaar data breaches to the Facebook Cambridge Analytica controversy, from credit card fraud to identity theft, we're open to just all sorts of cyber attacks. Now, India is a step closer to having a data protection law. The draft Personal Data Protection Bill by the Justice Sri Krishna Committee has now been made public. After consultations and amendments, this will eventually find its way to Parliament, where it should become a law. But we're asking tonight, why is this bill so important for you, the digital Indian, who uses smartphones, apps, social media, does almost everything online? Does it do enough to protect you? Well, here's a report by Nimisha Jaiswal.
A landmark legislation in the making. Finally, a data protection bill that covers corporates as well as the government, codifying the rights of Indian citizens over their data. The bill lays out clear guidelines for companies on getting consent on data use from individuals. It also defines the rights of the individual over the data, including the right to withdraw consent and to deletion. It recommends steep penalties for misuse of personal data. And importantly, it also sets up a 7-member data protection authority. But is it enough? Civil society groups are unsure.
It seems like more like enabling protection for the government, enabling mass surveillance and also protection for companies, and effectively not giving citizens the rights that the right to privacy judgment gave to them.
Cyber experts and privacy lawyers point out that under the bill, the government does not require consent to collect information. The bill skips putting limitations on mass surveillance, and while the right to be forgotten is addressed, the right to deletion is not. Even for companies, a requirement to save a copy of all personal data within India raises concerns. Is it simply so that law enforcement can access citizen data more easily?
So there are obviously serious economic implications, not just for global companies like ours, but also for Indian companies, for startups that find it more efficient and also more secure to sort of store their data on servers outside of India.
But advocates of the bill say it does better than give ownership of data to individuals. It places a fiduciary responsibility on companies to treat data responsibly and places restrictions on the government as well.
Even if the government wants information for national security purposes, it can only do it if it is authorized by a law made by Parliament. There are clearly circumscribed safeguards. The right to privacy, very important to everybody, is not an absolute right.
Experts agree that this bill is an important first step towards providing data protection, but given how much time we spend online, civil society feedback will be important before this bill is passed into law. With G. Shankar, this is Nimisha Jaiswal for NDTV.
All right, before we begin our debate tonight, a report that seems to suggest exactly how important such a law will be, should be. My colleague Keithley joining me at this point for more on that. The telecom watchdog, the TRAI chief, actually had a dare. He put out his Aadhaar details online, and he said, you know, do your worst with them. What happened, Keithley?
Well, this all started when the TRAI chairman said that, the government has a right to collect all your Aadhaar database and create all kinds of profiles because the government provides subsidy to the citizens. And then he started this dare that even if I put out my Aadhaar details, there is no harm that can be caused to me. And that is when this ethical hacker, Elliot Alderson, who's present on Twitter and claims to be a French ethical hacker, he got TRAI chairman's Aadhaar number, and then he revealed his mobile phone number on Twitter, saying that, this is the detail that I can obtain by getting your Aadhaar number. And soon enough, the other Twitter users also joined in, and a result of this challenge was that people revealed R.S. Sharma's mobile number, PAN number, the fact that he owns an iPhone, his address, his date of birth, his WhatsApp display picture was put up on Twitter, even though they morphed it slightly to prevent his privacy from being violated. Then his alternate phone number. And despite all of this, shockingly, the TRAI chairman's response still is that does not cause me any harm, does it? But we also spoke to certain experts who deal with cybersecurity and all of this data issues, and they say that even though details like phone number and address and date of birth are not inherently that dangerous when put out like this, but they can be used for several bank frauds. So people at certain times call you up saying that we have your address, we have your date of birth, we just need to know your account number because I am from so and so bank and we are trying to verify your details. So that is the procedure that is carried out for bank frauds, and that is why the Aadhaar number being revealed could put people in danger.
All right, so Keithley, thanks very much indeed for bringing this to our notice. This is something that's been happening, playing out today. It's the big buzz all over social media, and perhaps highlighting just why a data protection law is so important for your rights as an individual and your right to privacy. Let me take this straight across to our panel tonight. Joining us, Dr. Fergusson Gupta, Research Director of Vidhi Center for Legal Policy, someone who's been closely associated with drafting this bill, in fact. Shivangi Nadkarni, founder and CEO of ARCA, which is a data protection firm, is also with us. Karnika Seth, Supreme Court lawyer, also a cyber and IP expert, is also with us. So we hope to really explore all sides of this tonight. But Fergusson Gupta, you've been part of the drafting process. Can you say, hand on your heart, that this bill is the data protection law that India so desperately needs? Is it going to safeguard you, me, and absolutely everybody else who's online?
Hand on my heart, I can say that that's the case.
And why do you say that? What is it about this bill, which hopefully will eventually turn into a law, that you believe is strong enough to do so? What are the highlights in your opinion?
Well, I think the critical point to note is that India needs to be a free and fair digital economy. And this essentially entails two things: that the individual must be at the center of every data protection, of every data processing that goes on. And what this bill does is that it has there's a little bit of feedback.
Okay,
what this bill does is that there is a consent framework that it puts in, which is an informed consent framework.
Yes.
Now, this consent framework is such that every individual can decide for herself as to whether he or she wants to share her data. So in the example that you provided, the chairman of TRI, Ram Sevak Sharma, has now consensually shared his Aadhaar number with people. And that is an expression of his consent. So what the bill does, number one, is that it makes it clear that the individual is at the center of every data processing transaction that takes place in the country. Number one. Number two is that it makes it clear that if you have a case of identity theft, or you feel that there is a misuse of personal data that goes on, then in that case you have recourse to an authority, an independent regulator, the Data Protection Authority. You can get compensation against private parties as well as against the state. And the third, which I think is a critical aspect, is that as of today, the law does not apply to the government. Today, the Reasonable Security Practices Rules 2011 are applicable only against private parties.
Okay.
They're not applicable against the government.
Okay.
What this data protection bill does is that it makes it clear that the law applies both to the private sector as well as to the government. So if tomorrow you have a problem with the UIDAI and you think that your Aadhaar data has been misused, if this law were passed, then you can go to the Data Protection Authority against the UIDAI asking for compensation.
Okay. Important points there. And Karnika Seth is one of the critics of this draft proposal bill. You're saying that, in fact, okay, fine, the government may now, under this bill, be brought under the ambit of all of this, but you still feel there are loopholes. The government, in fact, does not require consent to collect information in the same way that corporates do.
Well, when you look at the bill as such, when it's in its draft stage at this point, One thing is very important to highlight here is that the word fiduciary is used.
Okay.
When we say fiduciary, there's a highest level of duty of care involved. Something like a banker-customer relationship or a lawyer-client relationship or a doctor-patient relationship. So the pedestal to which the data has now been given is a much higher standard of care which is there. Definitely, this is something which has not been there so far in India.
Okay. Okay.
Now, how that will play its part. Now, when it comes to responsibilities with the service providers, I mean, there's a lot going to be done at that level, and lot of checks and balances have been proposed. However, how these will be implemented and whether they will be able to really, have controls over the discerning powers of the Data Protection Authority, because they have been given huge powers under that bill.
So this is the first time that there is going to be such an authority, a 7-member data protection authority, which will be the arbiter on all matters that come before it when it comes to data protection.
What I wanted to say was that although we feel that the users will be empowered in terms of data protection, however, the wide discretionary powers which the Data Protection Authority has been conferred with under the bill is going to be something which we need to very carefully check it under a clear lens, because there have to be not only just very important principles that are there in the bill that will be followed, but the nitty-gritties. For example, who is after all a significant fiduciary? It has to be defined. What will be the parameters? How do you discern that?
Okay, so essentially, just to make this, before we get trapped in too much legalese, to make this simpler, as a user of various platforms, social media platforms today, I would go online, maybe download an app, and I have pages and pages of terms and conditions that I'm supposed to accept, which I don't read, and I'm sure most people who use Google or Facebook or Gmail, they don't read either. There seems to be in this bill the fact that consent has to be precisely obtained. That things have to be clear.
Yes.
I will know exactly what it is that I'm letting myself in for, who is going to get access to my data, and all of this is going to be under the ambit of this so-called fiduciary agreement that you're talking about. Isn't that making things clearer for me?
That definitely does. There are a lot of positive aspects of the bill, and I'm very happy that it's taken the shape. However, there are certain things which need to be looked at. Like I said, the wide discretionary powers. When we say right to forgotten, is another aspect which has to be highlighted. There is I would say a very greater deal of flexibility given under that law, that you can actually decide not to erase the data completely. I mean, that's possible under the ground of public interest, or it could be even under the ground that it is something which is an information in the public domain, or it is required, it's necessary to be, let the information
I want to take this back to Fergusson Gupta. So how would you respond to some of these criticisms that are being leveled? That the government does not require consent to collect information, that there seem to be no limitations on mass surveillance, that this point that Karnika is making, that the right to be forgotten is addressed in this bill, but the right to deletion is not. So once my information is out there, presumably it's there.
Yeah, so I think let's take all these 3 points in order. First, as far as the government is concerned, it's necessary to understand that public functions of the state are important. Now, let's take an example. Now, if the health ministry, say in a particular state, wants to find out as to why there is a tuberculosis epidemic in the state and wants to get personal information from all tuberculosis patients in that state, then surely they should be allowed to do so, because it is for the larger interest that this is being done. And when it is done, it's important to note what the bill says. The bill says that if you are taking information from a tuberculosis patient, you are only allowed to use it for the purpose of diagnosing possible causes for the tuberculosis epidemic. You are not allowed to use it if you want to now make a database of criminals. So there is a purpose limitation provision and there is a collection limitation provision. So under the garb of taking information of a tuberculosis patient, you can't ask for, say, her sexual orientation. That's something you can't do. So the first thing to note is that public functions of the state and the government is not a catch-all exemption as it's being painted in some quarters, not in this show, but in some quarters. It's not a catch-all exemption. That's number one. As far as the second point is concerned with regard to discretionary powers of the Data Protection Authority together with this right to be forgotten issue, I think the point that the lady was making before me is valid, as in there is a lot of discretionary power that has been given to the Data Protection Authority. And there's a good reason for that. Technological standards are changing every day. And given the fact that they are changing every day, and we know how our parliament functions, we can't change the law every day. So there has to be standards that are specified by the authority on an ongoing basis. And the principles on the basis of which those standards will be framed, which is in the case of right to be forgotten, is my privacy interest to be forgotten versus your interest, say, as a media house to report, which is free speech, is laid down in the law itself. That's the second point. And as far as the point about mass surveillance is concerned, I think it would be perhaps a little bit idealistic to think that a data protection statute would double up as a mass surveillance regulation statute. Now, we as citizens would all like mass surveillance to be controlled. I don't think that any citizen on earth who can say that they would be happy to be surveilled all the time. But the critical point to note is this, that there is no data protection legislation that we have studied worldwide which has mass surveillance related protection. What we say is that if there is going to be data sharing for national security purposes, it must be by law. And that by law, the requirement that it is by law is also provided in this statute.
All right, I want to take this, a step further, bring in Shivangi Nadkarni, who is the founder and CEO of a data protection firm. Shivangi, my question to you, and I'm sure this is something everybody wants to know. Yes, it's wonderful that we're working towards a data protection law, but will my data be automatically safe once this law comes into effect? Or am I as vulnerable as I was before? It's just that I have some legal recourse now.
Ankita, to say that your data is overnight going to be safe is, I think it's being assuming too much. I don't think today, even as we stand today, anybody, even the companies or entities who have the best of security practices implemented, can really turn around and say your data is absolutely foolproof safe. Okay, so that's the first thing. What I think a law like this will really help with is to put substantial reasons for somebody to actually go ahead and become very serious about implementing security, which today a lot of people are, have one foot away from saying should we not, despite being affected parties, unless there's a very strong regulator or customer sitting on their heads. That's the reality today. So I think this law is, first of all, a great step in ensuring that somebody begins to take something like this very seriously. Secondly, I think it does set a direction for somebody who wants to go in that direction of making things secure, so that they're able to actually go ahead and do something. It clearly lists out many things that an organization or an entity or government entity should be able to do. And I think that itself is a great first step, considering we were, literally below ground zero till now.
Right. Now, Shivangi, one more question. Since you work closely with companies also, there's a requirement to save a copy of all personal data within India, even if you're a company that is listed somewhere abroad or physically exists somewhere abroad. Is that simply so that law enforcement can then access citizen data more easily? Because that's a concern that's being raised by critics at this point.
Yeah, so while I'm not a legal person, so I'm sure Arga or Kanika will be able to give a better view of the legal implications of having data being stored in India. But I think as a practitioner or somebody who can probably speak from how a corporate would look at this, I think it is really curbing things. I don't think it's a great idea to compel people in today's day and age where data flows so freely across borders to have a copy compulsorily in India. Maybe for certain sets of data which may be deemed to be critical, sure, it makes sense. Now, whether having a copy in India will help from a legal enforcement point of view, I am not the right person.
Okay, fair enough. Let Kanika come in on this.
The localization of data that is being talked about in the bill is a welcome step. From a legal perspective, it is something like a blessing. It's something which we really need. It's the hour, it's like need of the hour. We don't have a convention to a cybercrime that we are signatory to, and having this data will be very, very, I would say, beneficial for any kind of legal process to be successfully contested. It's like something that we really lack evidence in many cases, and lots of crime cases and lot of investigations are actually stalled just because of lack of data.
Okay, but so that's broad specs, to wrap this up really, would you say the benefits outweigh the limitations of this bill?
Well, yes, certainly I feel that the benefits are there, and I'm quite sure about the positives on this angle. I mean, when you talk about the bill, it's really having a lot of positives, but yes, a word of caution, because when we say discretionary powers, we have to be very cautious of how those parameters are going to be implemented to maintain objectivity, which is really the intention. So that's something which I'd like to highlight.
Dr. Fergusson Gupta, respond to this. You wanted to make a point also, but wrap things up for us. Why should we be relieved as online digital Indians this evening, that there is something that is hopefully going to protect us down the line?
Well, I think today currently we were at the mercy of private corporations. Private corporations have been good. They have responsible practices. But I think it's the fundamental duty of the state to protect its citizens, especially because most of its citizens are online, and many citizens are online for the first time. So I think that this should be a matter of great relief, that in addition to the practices of private corporations, which are good, now you also have the state which is going to assure its citizens, whom it is democratically accountable, that it is taking care of their interests. And related to that, I think in terms of localization, which was the point being made earlier, I think we have to see localization in a slightly larger perspective. We are in an age today where most of the internet is controlled by 5 large corporations. And all 5 large corporations have huge interests in India. And I think if the corporations are going to benefit from India, then I think India should also benefit, and Indians should also benefit from their personal data. And I think if the data is localized in India, there are huge impacts for an artificial intelligence ecosystem developing and huge multiplier effects. So I think we have to see it in a larger context of where the nation state is. We have
to, of course, remember that this is possibly the first step that's been taken towards actually having a data protection law. There's a long way still ahead. This is when the consultations begin. There will be many amendments to the proposals in that draft bill. This is something we're going to keep talking about. But thank you all for joining us on this discussion tonight.